Chair Geffen had a meeting this morning, is running a little late, so I had the pleasure of getting us started. So just before we kind of get going too far, Will, could you do a roll call to establish quorum?
Certainly, Madam Chair. Ms. Basham. Ms. Basham. Senator Champion. Senator Champion. Ms. Dawson.
Present.
Thank you. Mr. Esme.
Present.
Ms. Evans.
Present.
Mr. Geffen. Mr. Geffen. Mr. Hanson.
Present.
Ms. Huntley.
Good morning, present.
Good morning. Mr. Urban.
Present.
Ms. Kaser.
Present.
Mr. Kammer.
Present.
Lieutenant Knotts.
Present.
Judge Gulick.
Present.
Senator Matthews. Senator Matthews. Ms. Mattson.
Present.
Representative Mueller. Representative Mueller. Inspector General Modi.
Present.
Mr. Page.
Present.
Ms. Robertus.
Present.
Representative Robbins. Representative Robbins. Mr. Sandoval.
Present.
Thank you. Judge Satterback.
Present.
Ms. Sherlock.
Present.
Mr. Tatum. Mr. Tatum. Ms. Williamson. Ms. Williamson. All right, Madam Chair, 17 of the 25 members are present. A quorum is present.
All right. Well, thank you everybody for coming today. I know it's Friday and the holidays are approaching, and I'm sure all of us are very busy. So I do just want to note that a copy of the December 2nd meeting minutes have been posted to the task force website. If anybody has any corrections, additions, edits, please speak now or forever hold your peace. All right, hearing no objections, I will declare that they are approved. So last time that we were here a week ago, we did cast at least an informal vote or a formal vote, to allow Will to continue the writing process. A rough draft was circulated of the report on Monday. And I think in all fairness to Will, that was obviously a rough draft report. And then another report was circulated, it was last night. And so, I think Will fully acknowledges, and we all acknowledge, there are certainly some typos and some even incomplete sentences or things like that that will have to ultimately be corrected. But I think the goal today is really to focus more on the substance of what is there rather than some of those typos. I think we'll fully acknowledge that those will be, of course, corrected and more a more polished version will be out, but we definitely want to focus on the substance and really focus on the underlining meaning of what is being said versus those edits there. And so I guess before we get started, in a prior kind of conversation with Ms. Evans, just since she is also a lived experience, before we start talking about really those substantive changes, she, and Ms. Evans, as long as you're still willing to do it, had said that she would like to at least briefly address the group before we get into some of those substantive conversations.
Yeah. Thanks, Ms. Dawson. I just, we were talking about kind of why we're all here, what started this. And it reminded me that I've never really talked about why this is important to me and how I got started down this path. My job with Minnesota Adult and Teen Challenge, I've been there 16 years. And when I first started with Teen Challenge, I worked in their prevention program, going out in working with the schools. And at that time, my parental rights for my kids were involuntarily terminated because I left in my serious substance use disorder. I left them with my parents and went to jail, went to prison, like all the things that go along with substance use disorder, and didn't come back for sometimes months at a time. When I finally went to prison the last time, my mom and the state went to file for termination of my parental rights, and I was in prison at the time. And I knew that it was happening and talked to my mom about it. And I just told her, like, you do whatever you need to do, what's best for my kids. And I didn't know that there was such a big difference between involuntary termination of parental rights and voluntary termination of parental rights. And so I didn't file for a writ to go to court to be there when it happened. And so I had this involuntary termination of parental rights on my record. And so when I filed for my DHS set aside, and granted, leaving my kids, abandoning them, doing some of the stuff that I did was horrible. But involuntary termination of parental rights is usually for a very different thing. And so when all of that happened and I got my letter back from DHS that said that I have a permanent disqualification, because back then involuntary termination of parental rights was on the permanent list, and it was like tagged on to the bottom, like as an afterthought. It was the last thing on the statute. And also, if someone's parental rights have been involuntarily terminated, they're permanently disqualified. And so I went to my legislator, Senator Olseen, and was just like, here's this thing, here's how it's impacting me. Like, I'm never going to be able to do this thing that I know that I'm called to serve people who have struggled like me. And so it took us 2 legislative sessions, but we were able to go in, and everybody told me, you're never going to be able to fix 245 C15. Like, nobody will touch it legislatively. And so at that time, pretty discouraging. I met people from Second Chance Coalition, and, like, long story short, it took 2 legislative sessions, but we were able to get that piece of the law fixed, and it got moved with voluntary termination of parental rights to the 15-year statute. And I was able to keep my job at Teen Challenge and all of that, but it's made me really passionate about this because, yes, my addiction was bad. Yes, I needed some time under my belt of sobriety, but who better to work with folks that have struggled with addiction and criminal behavior than someone like me, somebody like Leo, after we've gotten our lives together, to really show people that there's hope, right? There's possibility that you can get your life together and get it turned around. And there's pieces of this statute, when you look at the fact that somebody that's had, a felony second-degree possession, or, a lot of my crimes were check forgery and stuff, that the way things stand right now, that, it's 10, 15 years before they have to stop answering for that behavior. And it can cost people jobs, better paying jobs. And so I just wanted to remind everybody, like, yes, statutes, yes, law, yes, all these things that we're looking at. But at the end of the day, what we're really talking about here is people and families and people's livelihood. And I just wanted to bring that back and remind people what's the important thing, and that it's not numbers and laws, but it's folks, it's people. So thanks for hearing me.
Thank you very much, Gina, and thank you for speaking up. I know you've been quite a voice in all of this and supportive of balancing, I think, the goals of the task force and trying to help move us all forward. So thank you very much. So I guess my thought, as we were thinking about how to go about kind of looking at this document and talking about really those substantive edits and making sure any sort of clarification is there. My thought was to attempt to do this in some sort of an organized fashion, rather than jumping all over the document, unless anybody feels differently. My thought would be to share the document on the screen, and we can go through, start at the beginning, and hopefully not focus on every single page, because then I don't think anybody has set aside a whole day. But then we can do that. And I think those of you who've been in meetings with me before know I just like to share my screen, and we can maybe put in comments or edits as we're going that can then be recirculated, so everybody has essentially that working document as to the edits that are proposing, and even maybe highlight comments and specific concerns or anything like that, so that we have that transparency. If that's anybody has any other idea, I'm definitely game to hear it, but that was the idea I had. Yes. Modi. Yep. Sorry.
I just wanted to let you know that, no, I think your approach, I don't have a question about that, but I just wanted to let you know that, we are in a very busy time for us here at the state agency. So I do have to step out. I'm double booked a bunch of this, but Autumn Baum, our legislative director for OIG, is here and is authorized to be able to speak on behalf of DHS on that. So if you see me in and out on that, I will say that DHS has taken a look at this. We've provided some formatting and other suggestions given on our experience in writing lots of legislative reports and stuff like that. So we've provided that to Will as just, some general feedback on that. And then we do have some specific comments from our perspective too. So we'll be able to share that. But I just wanted to let you know that if you see me in and out, and if I'm not here to, you can refer your DHS questions to Autumn.
And thank you, Inspector Modi. I'm really glad you actually brought that up. Will did get those proposed edits. They were this morning, so I know it's not been circulated to the entire group yet. And maybe, I think what we were hoping was, of course, as we're looking at the substantive, especially since some of the edits, as you mentioned, were more formatting and, maybe a slight linguistic change, that as we're going through this document, we definitely want to hear from DHS their thoughts if it's a substantive concern, so that, or a substantive change or whatever it might be, so that we can all understand and can all have that open discussion. So I'm really glad you brought that up. Thank you very much.
Right. And we'll do our best on some of this, but it was, thank you, Will. It was a great document. I know how much work that goes into this, but it did take us quite a bit to get through it all. So thank you all.
Yes. So I'm going to go ahead and attempt to share my screen and share the correct document. Hold on, it's not showing up. Hold on, everybody. Sorry, I might have too many things open on my screen.
Chair Dawson, as you're opening that up, I just want to just say hello to everyone, and respectfully, Inspector Moody, I still have not received any correspondence from your office. The statements that you made as fact, I would really appreciate that. I would really appreciate scheduling some time with.
Thank you, Ms. Williamson. Yes, we were able to gather that information, and I will be having someone reach out to you so that we can schedule some time. But as I said, we've had a lot to work on, and we hadn't forgotten this, and so we've been able to take a look at it, and we'll be able to respond to you.
So much. Thank you, Chair Dawson.
Yes, absolutely. Thank you. All right, so hopefully I pulled up the correct document. I think this is the one that was submitted emailed out last night. Will, thumbs up. Perfect. Thank you. Okay, so I'm just going to start scrolling, if everybody's okay, until we actually get to the substance. All right, so we're starting here, the executive summary. And Will, could you just very briefly, I take it this is you pulled from something specifically?
Madam Chair, if I'm understanding your question correctly, yeah, I pulled from the remedies and disqualification subcommittee recommendations that were voted on last week, and I basically just wrote this to try to summarize those 7 major recommendations, as well as a very brief introduction to what exactly Chapter 245C is and what the task force is. But I suppose, like, in a sense, this is my language here. So any corrections, I definitely appreciate.
All right. So just starting off, I guess, I know this is, it notes 34 pages. I guess I can just sort of briefly pause here, and unless somebody raises their hand, I'll, keep scrolling. So if that's all right with people. And if I don't notice you've raised your hand, please speak up, because of course, when I share my screen, you all sort of move to the side in smaller boxes. Judge Satterbach.
Just quick question. Are you wanting us to just comment on substance, or do you want us to actually go through and comment on more of the, some of the mistakes throughout, not substantive
Yeah, so I think, if there's something glaring, or if you feel a word choice would change the meaning, I think that's definitely important. As far as typos, I think in my conversation with Will, he is planning to go back and do a much more thorough edit and, for example, typos and things like that. So if there's something specific that you notice, Judge, that you would like, that you think is important, I don't want to silence anybody. I just want to, of course, make sure that we are using our time efficiently.
Okay, makes sense. Thank you.
And Ms. Sherlock.
Thank you, Chair Dawson. I had the same question, and I'm going to go just a little bit further. Like, can we, if we had noted things that weren't substantial content changes, can we email those to Mr. Vogel? Okay.
Yeah.
So I don't know if this is a judgment call if this is a picky detail or not. But in the very beginning, this is setting the stage for the whole report. So I'm wondering if it's in the 4th line, it says working with vulnerable adults as well as caregivers of foster children. I think we need to add vulnerable adults and children. Not all of the children in this field are foster children. And instead of like a parenthetical addition of the caregivers, can we make them like not parental, just like a list of, we're talking about people who work with vulnerable adults and children and caregivers of foster children.
All right. And Ms. Sherlock, I think that I can definitely appreciate that. And of course, this is the first piece that someone will see. And I guess unless somebody feels differently, maybe I add it as a comment, and then Will, you can work on finessing the language. Does that sound good? So,
Ms. Dawson,
yeah.
This is Inspector General Moti. We have provided as part of our feedback language on that because, as Ms. Sherlock said, it's for us, and the way that we reference it and how we talk about it is vulnerable adults and minors, because it's not just foster care children. It's and that's one thing that we've kind of noticed is childcare is a big component of this, and there's not necessarily a lot of conversation around that in there. We also do children's residential facilities, PRTFs, and stuff like that. So we refer to it as vulnerable adults and minors is how we consistently talk about that. And I know that was in some of our feedback that we provided back to Will, and that is consistent, and also how we and the legislators have also talked about it. So that might be something that you guys would like to consider, and that they'll understand that. So Ms. Sherlock, you got there before I did, but I was going to raise the same point.
Okay. And obviously, I just did a brief summary comment there. So if Will, that's enough for you to at least, I guess, kind of work on that edit, and we'll go from there. And if anybody has anything else for this page, I will wait. All right, hearing nothing else, I'm going to skip past the table of contents.
Looks great, by the way. Well, aesthetically.
Yes, well, you definitely put in the time and the effort. I do definitely want to note that for you. Inspector Modi.
We have some suggestions that you may want to add, and what we've done before in the past is a membership list at the beginning of it, and maybe putting together an executive summary on that. And then I believe membership list with affiliations, an executive summary, and then highlighting at the top, usually a summary of your recommendations, and then you can get into further explanation below. We found that with those that are reading it, if we can put exactly everything we want up at the top, then they can read further below. But then if they don't read past page 4, you've gotten the most important information out there.
That's great feedback,
Yes.
Luani, because sometimes people only read the first 4 pages. So whatever we absolutely want them to know should be in that executive summary, and expect that. I think lots of people are only going to read that first little bit. So whatever is the most important should be in that executive summary in that first 4 pages. That's super important. I co-sign that.
Yeah, so I just added a note of membership lists and executive summary recommendations, essentially pack as much as possible into the first 4 pages. And I think Inspector Modi, those were some very helpful comments, and thank you very much. I can fully appreciate that we want to make sure people get especially what we need and nothing gets lost. And I'm learning how to do these comments. There we go. All right. So okay, so then looking at essentially the overview, an overview of 245C. Inspector Moti.
One I do want to note that 245C, Chapter 245C is known as the Human Services Background Studies Act, not as the Department of Human Services. So because more than just DHS point to the statute. So that would be one that I want to do. Again, we have provided some suggestions, edits, and comments about who does access them, what agencies. It's not just DHS and MDH. I don't have all the specific language with me right here because we had edited the previous documents, or I'm struggling to track all of it. But it's also DOC, it is MnDOT and various places. So I just wanted to note that.
No, thank you. That's very helpful. And I think that's very important to remember that the 245C applies to a lot more than, as you said, just DHS. And so these statutes have to be sort of thought in a bigger context than just that. Judge Soderbeck.
We might want to put a footnote then that describes that it's not just Department of Human Services, because if you actually look at the statute, the title of the statute says this chapter may be cited as the Department of Human Services Background Studies Act. That's probably why that's in there. So, I mean, that's just a technical, right? It's just technical, but I just wanted you guys to know that.
Thank you. And I think just so that everybody knows, I think we'll of course finish digesting some of the edits that DHS had sent over shortly before our meeting today to incorporate those. And then, of course, get out a revised edit based on this meeting as well as those as soon as possible so that everyone has time before our next meeting. Mr. Esme.
Kind of a small one, but very last couple lines on the page. It says DHS to review juvenile court records and may disqualify an applicant for having been adjudicated. I would probably change that to must. I don't think DHS has discretion currently to treat juvenile records any differently.
If everyone's okay, I'm actually just going to make that edit. It'll obviously track rather than doing that one as a comment since it's a word change. And I apologize, everyone. I know this font is small. If people would like, I can try to expand it, but I'm worried since I have the track changes on, that's going to mess with the formatting. Inspector Mulkey.
One thing that in the overview of 245C, some of the stuff does cross over to functions, at least for DHS, into chapter 245A. So again, we've made these notes. I just want for the larger groups to know. I know, Will, we've provided you a very detailed document, which I hope is helpful on some of this, but I just, for us, some of that crosses into 245A, which is our Human Services Licensing Act.
And that is helpful. Thank you. Mr. Esme.
Thank you, Chair Dawson. If you want, I think under the view tab at the top, you can zoom in on the document without changing the size of the font. So that might, yeah.
Hey, thanks. All right, so unless there's anything else specifically on this page, I'm going to keep going. And as was noted, if anybody has anything specific, if they're not sure about speaking up at this moment or they don't get a chance, please feel free to email Will and we can have that incorporated as well. Thank you. Ms. Sherlock. Oh, you're muted, Ms. Sherlock. Ms. Sherlock. There you go. That's okay.
In the paragraph that starts the beginning of the look back period, I wasn't sure if I just wasn't understanding what was said here or it wasn't making sense. So that paragraph starts where it says, for example, and it starts with a conviction of misdemeanor and what that means. And then it goes to a preponderance of evidence determination. And then as part of that, it talks about the applicant committed the misdemeanor will begin 7-year disqual period from the date of the dismissal, the date of discharge of the sentence imposed for conviction for a disqualifying crime of similar elements, or the date of the incident. It was confusing to me why there was something about a conviction in a description about preponderance of evidence.
Okay.
So I literally don't know if it was just me not getting it or if that isn't quite right.
No, I think that's fair. And as you're bringing that up, it does appear that is a very long sentence. Maybe at least for just right now, rather than specifically looking at all of the wording and spending our time, I'll do a comment to just say, clear up the language.
Excellent. Thank you.
Yes. Okay. And I'm doing my best to scroll and watch for hands. So again, if I miss somebody, please speak up. Ms. Sherlock.
Thank you again. Okay, I'm on page, are you on page 5?
Yes.
Oh, not, okay. So on page 5, the paragraph, the right at the top, it's your mid paragraph joining in. At the end of that, there's a sentence that starts, applicants must likewise choose. Do you see that?
Yes.
Okay, so this could just be me, but when I read that, it does not serve vulnerable members of the community like the applicant wanted. it sounded kind of creepy to me. I'm going to be really honest. It sounded like a little bit like a pedophile looking for victims when they talk about who they want. And I think that needs to be reworded. And I had some, I wish I can send to Will. I'll send him my document in its entirety. But just think about revising it in some way that talks about perhaps applicants must likewise choose whether to risk their livelihoods by pursuing a caregiving position they desire or to seek work less desired but not subject to background study requirements in Chapter 245C. Something like that is what I was thinking.
Okay. Yeah, and I think just for time, if you wouldn't mind sending, definitely I'm happy to hear all of this, and I think it's helpful for the group to hear it as well. But some of those where you have specific ideas would be especially helpful, I think, for Will.
I absolutely will forward this when we're done today.
Thank you very much. And do you still have your hand raised, Ms. Sherlock? Okay, perfect. I just wanted to check. Thank you. And I know some of these where it has that we'll be adding quotes and things like that. I guess, Will, unless you feel otherwise, if anybody has any strong recollection of a specific quote or anything they may want to send to Will, I'm sure he would appreciate the assistance as well. Inspector Moti.
I have one kind of in general about this. It's on page 7, and the task force believes that its first paragraph, couple last lines on it, is no longer needed to protect the public safety. And from a DHS's perspective on this, it's public safety, but it's also really our focus is on the health and safety for the vulnerable adults and minors that we serve and that are being served in this. And so just wanted to share that as feedback, as that is really the focus that we're looking at, that and the balance between affording those that may have things in their history that need to be taken a look at and want to still provide services to that with, the health and safety of the vulnerable adults that are being served.
Thank you. Yes, Ms. Kaser.
Sorry, it took a little second to find my hand.
That's
Wondering
okay.
when you're talking about the states, and I guess I didn't look in the quote, are we going to be quoting all of the states that we looked into or citing it in some way, just so that's referenced? Because it just says multiple states, but it's just an idea.
Yeah, no, that's a good question and a good point. And let's see, which page was that? I'm so sorry. Maybe I scrolled or didn't scroll far enough.
I believe it's up on page 7. Sure.
Okay. Okay, similar laws to other states. Yeah, I think I like that idea. And I think, I don't know that we necessarily always looked at every single state, but well, maybe what would be helpful is, I think, at least in the remedies subcommittee, at some point we may have had, I don't think it was necessarily a table, but at least specific references to other states. Maybe that could be an easy piece to find, and even if it's just a footnote or something like that, so that that's there to support that statement.
That makes a lot of sense, Madam Chair. As a suggestion, I could essentially include all that information as an appendix and reference it in this text here, if that sounds good to the members.
That would work, I think, and Ms. Kaser's nodding her head. I like that idea.
Okay.
And thank you, Ms. Sherlock, for waiting as I was trying to furiously type there.
Not a problem. Before I forget, I want to echo what someone said. I think, Mr. Vogel, you wrote this document based on sitting in these meetings for over a year and taking notes, and I think you did a fantastic job. So I just want to say that. I'm on page 8. I thought you would scroll, but then you went back. So I'm not sure if we're on 8.
That's okay.
Okay.
I went back. I had gone too far. So I have now gone back to page 8.
So the next comment I'm going to make, I think I know what we're talking about here, but I was trying to read it from a perspective of people who haven't been sitting in these meetings and listening to all the great research and, lived experiences that we heard about. In that first mid paragraph, it's after, do you see the 13, the reference to 13 way up there? And then it starts Miss Delwo. It's about the 6th or 7th line into that top paragraph.
To the top paragraph.
Right. Do you see there's a note for number 13?
Oh, yes. I see the foot. Yes.
So right after that, it's that sentence. It is often applicants with a past. Do you see that?
Yes.
Okay. So I think I know what you're saying here by a past, but I think that needs to be clarified for people that haven't been sitting here. So if we are talking about applicants with past chemical or substance abuse issues, with past criminal history, with both, or criminal history because of a previous period of substance abuse, I just think we have to clarify exactly what we mean by applicants with a past.
Thank you. And definitely I can appreciate that. We've all sat through these meetings and we know what it means, but we're asking somebody else to read it who has not been here. So thank you. That's a very good, something that's very important to keep in mind.
Yep. And that would be like at the front end where we talk about when we had the doctor come in from Harvard or whatever, this would be a point where we could say, as discussed in paragraph 2, then you could just refer folks back to where we've already established fact, right? Or established information.
All right, so now we're going to be getting into the actual recommendations themselves. And so Inspector Moti, if you are still here, perfect. So yeah, if this will be definitely important. And of course, we'll want to hear concerns or comments from others, as these are the recommendations where we're asking for change, or where we're asking for changes. So I am down, again, I'll watch for hands, Mr. Esme.
Yeah, another kind of just small one, that second line of the first sentence under juvenile offenses, despite the fact that these records ordinarily remain sealed in adulthood. I think that's sort of an awkward and indirect way to say that those are private records. Ordinarily, those records are private records and not accessible by the public or something like that, I think.
Well, and I also want to be careful because 16 and over is technically it's not necessarily easily accessible, but
if it's a felony, yeah, that's true.
So there are some distinctions as to what is technically publicly available, and sealed, I think, is more, and I get this is more nuanced, but sealed is more what we look at with an expungement versus a private record and a public record. So just
we could say something like, despite the fact that many of these records are not publicly accessible, something like that. If we're just trying to have a general point about the distinction between adult and juvenile records as far as public accessibility.
Yeah, that's good. Thank you. Mr. Page.
Thanks. Good morning and good to see everyone. Would it make sense to do a statutory reference at that point that talks about the public versus non-public juvenile records? I don't have it offhand, but I could find it pretty quickly, I think.
That might be helpful for Will, if you wouldn't mind. Just makes one thing a little easier for him. If you could just email that to him, that would be great, Mr. Page. Thank you.
I think it might be 260B171, Max.
All right. So just continuing to scroll. And I think, well, there may be a few other places where that sealed word may be used in the juvenile. Maybe just sort of do a double check to make sure that's consistent throughout the this section. I did that. Ms. Robertus, thank you.
This is take it or leave it, but beginning here, we start to use the word fair and unfair. I'm wondering if we can just switch that up to something more impactful, whether it's inequitable, disproportionate, incongruent with research, those type of verbiages versus fair and unfair. I think fair and unfair is fairly loaded. Just a thought.
So more of an objective.
Yeah. So like I think below it talks about brain science, right? For juveniles, as they go into adulthood, it says it's unfair. I think something like that could just indicate, it's not supported by research. This concept isn't, congruent with what research tells us about brain development, for an example.
Thank you. And well, hopefully all my comments will somehow make sense for you later. I think some of these are more for your assistance, but also then, of course, as people are looking back. Okay. All right, so I guess without moving on too quickly, I have finished scrolling through the juvenile language and recommendations before I move on to the length of disqualification. Last call for any concerns, edits, comments. And of course, again, as always, feel free to send a separate email to Will as well. All right, I'm not seeing any hands. I'm going to move on. All right, length of disqualification. And again, I will start scrolling slowly. Inspector Moti.
So we do appreciate all of the work and the thoughtfulness and the approach that the task force and the subcommittee have gone on this, and understand the rationale and the reasoning behind moving to a two-tiered system from DHS's perspective. And we would provide this as more of like we would provide this in general just as kind of technical assistance and on it. We do think that there needs to be changes, but we're looking more at a three-tiered system, partly given that that allows for the span of the varying different crimes and conduct that we're looking at. That also lines up with the very different settings for which provider settings for which we do background studies for. There's a difference between a PCA person, foster care, TRTF, a child care on that. And so from DHS's perspective, we think not a four-tiered system. So we do think there needs to be shift from that, but that there needs to be something in between a 5-year and a permanent.
And so what would that look like, Kulani? Like I saw that in your comments, and like, is it super secret what you're thinking, or can we know?
What I was thinking and what we've been discussing kind of internally is there are some that, first of all, the removal of the permanent the permanent bar, not necessarily the permanent disqualification, which then will allow us to be able to look at more scenario, like specific fact-based scenarios on there, but then to see more of a 5, 10 and permanent. There are just some that the 5-year really give us pause that on there, but understand that 15 might be too long on that. That's our thinking right now. Would be open for further discussion if that should be a 7-year, but we think coming back to 5 and 10 and then like a permanent on that.
Thank you. And just before I get to you, Mr. Hanson, Inspector Modi, I just want to note, I did put the note specifically as DHS. I'm not trying to specifically call you out in any way, but I think it's just helpful, especially as we're going back to look for something like this, where it's kind of the specific thought process and proposal to be able to remember where it came from. So I just want you to know, I'm not trying to pick on DHS in any way. I'm just trying to be clear.
I appreciate that. And know that in general, we're supportive of this and we do appreciate this and see the need for changes to be made. But just looking at that and just kind of from our subject matter expertise and standpoint, would be looking at more like that. So I will now defer to my colleague at MDH.
Yes, thank you. Mr. Hanson, thank you for your patience.
Yeah, thank you. Thanks, Ms. Modi. Yeah, MDH, I'd just like to echo kind of what Inspector General Modi said, is that we'd like maybe an extra tier in there of disqualification periods. We're certainly supportive of reducing the lengths but being a little bit more cognizant of the different kinds of offenses that are disqualifying, and some of them should be treated longer than others. Placing all of them in either a 5-year or a permanent bar seems a little bit inflexible and doesn't kind of mesh with how, as a department, we look at these offenses on reconsideration. Some of them are less likely to be set aside after a certain period of time than others. So just, some of those offenses that are identified below that maybe we're considering not disqualifying, maybe would be better fit into a shorter disqualification period that kind of matches with our current practices on reconsideration.
Thank you very much.
Madam Chair, if I could.
Yes.
I'd just like to note that since I am sort of working up this text, as far as I understand, I've currently been directed by the task force based on the vote last week to write this report focused on the 2-tier structure that the disqualification subcommittee recommended and that were in those recommendations that you voted on. So if you'd like me to include language noting that the departments, or just generally language suggesting that some members suggested a 3-tier system, please just let me know. That just feels like a substantive enough change from what's been voted on right now that I appreciate some formal direction on that.
And I guess I know what I think, but if this needs to go to a vote or I'm not sure. So I guess Mr. Vogel, please tell me. I am a fan of transparency, and I would prefer a document that encompasses all viewpoints. And so my thought, and again, if it has to be voted on, please let me know, would be to include language as to other thoughts and proposals from the group. Because especially as this document is going to the legislature, it's going to go through a process there as well, that I would rather have that transparency. And I guess as somebody who practices in this area, and I think as even Inspector Modi has commented, we all agree there need to be changes. And I would prefer to see changes rather than get stuck into a rigid, there's only one way thought process.
Yeah, and I would say, because it's not just like one opinion, not that one opinion doesn't also matter, but because it's multiple opinions, that are thinking the same thing, that's almost like a minority report, right? And so underneath this section, you could just say, and I don't know if the departments want to be named or don't want to be named, but you could just say a subsection of the group agreed that a 3-tiered system would be appropriate for these reasons, so that we're calling that out, and they can, the Department of Health and the Department of Human Services can maybe decide if they want to be named specifically or to just leave it vague. I'll leave that up to Mr. Hansen and Ms. Modi.
And so, well, I just added a comment, if I can just approve it.
This is something of a judgment call, Madam Chair, but I feel comfortable like just working from your direction as chair.
Then I will give you the approval and please add it. All right. So I guess scrolling then under, and I think then as we all are looking at this length of disqualification period, just keep in mind there's the other thoughts from Inspector Modi and Mr. Hansen on their thought process. So that's always definitely an option there. So yeah, if there's other specific comments about, as I just scrolled faster, this length of disqualification, please let me know. All right. If I'm not hearing anything else, I'm going to move on to the list of disqualifying offenses. I think we're making good time here, people. All right. So moving on to the list of disqualifying offenses. I believe there were, and Inspector Moti, I'm not trying to put you on the spot, but I do believe DHS had some specific thoughts about those.
Yes, and if I can have a moment before, and I'm going to have to step out in a couple of minutes here.
Yeah.
The department does have concerns with, although understanding with crimes related to fraud and fraud activities, understanding the situations for which people may have committed or have been found to have committed those crimes. We understand that, but from a DHS perspective, and when we're looking at the health and safety of vulnerable adults, the particular situations for which people may be in vulnerable states and receiving care from someone, and it's in their individual homes, in their very kind of not saying this well, settings where there may not be as much supervision or other people around. We aren't necessarily in supportive of eliminating all of these. They may need to be shifted into a different disqualification period on this. Again, we do look at them at the individual level and at the specific circumstances around this, but the department does feel that eliminating these would be concerning for us. So I know you're typing that. That wasn't the most succinct, but we just
and I don't know that my note is the most clear, but hopefully we'll all know and all understand, I think, the point that you are trying to make. So hopefully that's
especially about disqualifying offenses that are related to defrauding public programs.
And I think Mr. Hansen was first, so I apologize if it was actually Ms. Robertis, but I'll just go on the top of my screen. So Mr. Hansen.
Thanks. Another area where I'm sort of echoing DHS's concerns, particularly of concern is our home care providers, where caregivers are going into people's homes and providing healthcare and have access to all of their possessions and financial information. Theft offenses raise a concern in those situations. We're not only considering whether somebody's going to physically harm, but whether there's going to be a likelihood of financial exploitation of those vulnerable adults that are being served. So theft offenses, while they're not technically a safety issue, they do raise maltreatment concerns, particularly in home care settings. it's not all thefts are near innocent shoplifting situations, and we just would rather be able to review theft offenses to assure that those people are not likely to commit theft from the vulnerable adults they're being serving. So, thank you.
Thank you. And Ms. Robertus.
I was just saying, I was looking for just a little bit more context with DHS's concerns. I think Ben hit on it then with his follow-up. Thank you.
Okay. Mr. Hanson, do you still have another question or, okay, all right.
Oh, sorry.
No, that's okay. Just want to make sure I'm not missing something. Okay, so I'm just going to continue scrolling. So we're on to the specific recommendations, obviously understanding the concerns. And again, Will, I think, again, here, definitely the additional comments. I think anywhere we've got these real substantive, important comments and thoughts, please go ahead and include those. And I apologize, everybody, if you'll give me about, I know I'm leading, but if you'll give me about 30 seconds, you can look over this list. My dog has decided she really needs to go outside, and I don't want that on my carpet. So I will be right back. Mr. Esme.
I'll just jump in while you're taking care of the dog.
Thank you.
So I wasn't a part of this particular subcommittee, so I wasn't sort of privy to all the discussions that went in on here. But just taking into consideration the concerns that were just raised about this list, I'll go out and say I'm on the other side of it. I think it does make sense to remove this list of offenses as disqualifying offenses. But I wonder, because in my view, they are, even though they are sort of theft and honesty related, they're the nexus between them and a theft from somebody that you're caring for is distinct enough and different enough that I don't think that their predictive value is enough to warrant an automatic disqualification. So to that end, I wonder if it might make sense to have some language in here about the theft and honesty related offenses that the subcommittee did not eliminate, right? Like financial exploitation of a vulnerable adult, both as a felony and I think as a misdemeanor, remains a disqualifying offense. And I don't know if there are others, but it might be, especially if we're going to have sort of a minority opinion. I think it'd be good to sort of flesh out both sides of that argument for our readers to consider.
Ms. Sherlock.
Thank you. And I just want to kind of tag on to what Mr. Esme said. And I was in this subcommittee. We talked a lot about a lot of these crimes. We went over and over and over all these crimes. We tried to distinguish what we were calling crimes of poverty, trying to get at like theft that weren't also harming people. Like you're talking about financial exploitation. We also talked about, we wanted to simplify this process, but it would really be nice if we could have DQs for kind of these financial crimes if the job that you were doing gave you access to people's finances. But it's my understanding there's people in all sorts of jobs that don't even have direct access to clients per se, and they still have to be subject to these same background studies. So we're trying to address disparities through this whole process, and who, thefts of poverty or crimes of poverty, are going to impact communities of color more than not. And so we were trying to get at some of this. So I think we did leave in any of the crimes we thought could reflect back to a vulnerable adult or a minor's well-being, whether that be physical or financial. So I just want to throw that out there.
And then just as a reminder, like employers are still going to do this stuff and make decisions of their own. It's not like if DHS isn't doing set-asides and background studies and disqualifications based on these things, that employers aren't going to make decisions based on these crimes. And so it's just, some of this is just putting those decisions into employers' hands instead of the department. And
Thank you, Miss Evans. That's exactly why I started to make a comment, that piece of, and I just went off on a tangent somewhere else. That's what I wanted to get out, that we talked about. It would be the employer's discretion. What is that? What are they hiring that person to do? And give them the discretion to decide, is anything in a background study that's discovered going to be applicable to the job that they're being hired to do?
All right, thank you. And I think all of these comments are very useful and very helpful to give then, of course, the legislature the full picture and a better idea of all of the discussions that were had and the reasoning. So thank you, everybody, for all of your comments. All right, and I'm going to continue scrolling. So before I move on from the removal of any of these specific crimes, any last comments on this specific category before I move on to the date that the disqualification period should begin? Not seeing any. Moving on. All right. So, and again, as always, please speak up if there's anything specific. Judge Satterbach.
I'm sorry, this might already be in the document. So I'll admit I haven't had a chance to fully read this. I've been in jury trial this week. But when I'm going back to the recommendations for reducing some of these crimes or eliminating them entirely, I'm just wondering if somewhere in the document is described. So we say, for example, on page 12, under the recommendation, eliminate any misdemeanor, gross misdemeanor offense that does not involve the health and safety of a vulnerable individual. And we're using that same language, throughout, that does not involve the health and safety of a vulnerable individual. Somewhere in here, do we describe what the group is suggesting, what those parameters are, so that they know, so somebody who maybe is not familiar with these knows what that means when we say that does not involve the health and safety of a vulnerable individual?
That is an excellent question. Essentially what you're looking for is, do we have a definition of what is our definition of involving the health and safety of a vulnerable individual?
Right. Just because I'm thinking, if any of this were to actually, if we can get it forward and changed and passed, practically speaking, the people who actually have to go back then and interpret this, what does that mean? How do they screen for that? How do they look for that?
That is an excellent question. I've at least made a comment, and I think that's a very good point, so that we're all, as we're talking about this, we're all using the same definition and the same understanding as it applies to the recommendations on our thought process. So thank you very much. And I will, Judge Satterbach, I at least put that there. And of course, we'll go back to go through the document and make sure we're clear on that one.
Thank you.
May I jump in briefly?
Yes.
Just to make sure I understand correctly, that language is language that was used to describe essentially why the following list of offenses are recommended to be removed from 245C, right?
Yes.
So that language itself is more descriptive of the subcommittee's process to reach the recommendation that list of 8 offenses or whatever be removed. Am I understanding that right?
Yes. And I think, as Ms. Sherlock commented, our group went through very clearly to identify was something a person crime, a property crime, or a crime of poverty. And so perhaps including additional language about those conversations and how we identified it So for example, any of the person crimes, your assaults, your robberies. I don't have the list in front of me anymore to remember. But we went through in quite a bit of detail on that. And actually, I'm wondering, I think so if we can maybe include some more language about those conversations, because I think that really supported how the group got to where it got. And how it then defined that health and safety. Judge Satterbach.
Okay, so sorry, just maybe I'm misinterpreting. So how I read it, I read this as that the group is suggesting we remove these crimes from the list unless it involves a health and safety of a vulnerable individual. If that's not the group's intent, then I think you just take that language out and say the group is recommending eliminating any misdemeanor, gross misdemeanor offenses as follows.
I think that was the intent. And so maybe we switch the language around to say the thing it does include instead of the thing it doesn't include. So eliminate these offenses unless it involves the health and safety of vulnerable individuals.
Okay, that's how I read it, which is why that's why I was saying if we're carving out the offenses that involve those, then we should define what our definition is of those exceptions that we see.
So just to make sure I'm understanding now, what we anticipate happening would be DHS sees a theft conviction on someone's record and then has to make a determination about whether that particular theft involved the health and safety of a vulnerable individual?
No, so we're actually saying the misdemeanor, and I guess somebody can correct me, but would be that a theft, whether a misdemeanor or a gross misdemeanor, does not involve the health or safety of a vulnerable individual.
Okay, that's what I thought.
And I think, yeah, if we perhaps change it rather than in the negative to the other way, as Gina suggested.
Yeah, what we're saying is that these crimes do not involve the health and safety.
Yeah.
Okay.
All right. So then I think if there's no, Ms. Sherlock.
I just want to make sure I heard correctly. So we're going to maybe add some more detail about the work that the subcommittee did, as you said, Ms. Dawson, property crime, person crime, et cetera. We also, those were painful meetings where we went through every crime on there and we're looking it up in the statute to read actual language to determine what was a misdemeanor versus a gross misdemeanor versus a felony. And I think we should have something in there that explains the depth of conversation we had about all of these crimes, that it wasn't, we just didn't just go in there and say, okay, let's get rid of these crimes. It was a thorough process. Now, it's obviously still our opinions. It was this subcommittee's opinions, but I think we need to explain well what that process was like.
Ms. Robertus. And thank you very much, Ms. Sherlock.
I think that would be good as well. I wonder if I'm just confusing myself here. But when we say eliminate any misdemeanor, gross misdemeanor offense that does not involve health and safety of a vulnerable individual, and then we have some of these things below it, do we know that? I mean, I think we just described some examples where it could, but then, the employer can review some of that material and make some of those decisions. So for me, the more we talk through this, and I envision this is what will happen if this gets moved on, are we boxing ourselves in a little bit here? Could we just say we recommend to eliminate these due to low risk, right? It's not saying no risk, but there's low risk. And then say, include some of those explanations that you guys discussed, that you guys thoroughly work through, that employer still has some discretion, that there's many that protect that we are keeping on the list because they directly involve. So sometimes when you box yourself in and make some of those statements that might not totally be true, I just wonder if it will get hung up later on if we just more talk about low risk. It's just a thought.
I endorse that. That makes a lot of sense to me.
Okay,
I agree. I love
right.
that idea.
I love it. And of course, I know Will is on here, so if there's anything specific he needs for additional clarifications, I trust he'll speak up. Okay, the date that the disqualification period should begin. Ms. Robertus.
Sorry, I feel like I don't want to monopolize. If you scroll to 14.
Yep.
And where is it talking about release come from confinement?
Well, there's one under the recommendations of release from prison. There's another one above it though.
Oh, yeah. So Minnesota's a 2/3, 1/3 state, right? And so when you're talking about the recommendation to the date of release from prison, I understand the concept here, and I totally get, I totally support. However, my guess is there'll be questions about release violators and folks that are returned to prison during their last stage of their confinement. So I'm just wondering if that needs to be more specific about what the intent is. So are you saying CRD no matter what, even if the person is completely unsuccessful after their release and are returned for a discretionary date? So just wondering if there was any discussion there.
And I honestly am not sure if, and I hate to pick on him, but I know Mr. Page had some of this also based on his prior work on the other committee. I can't see all of the names when I'm sharing my screen. Does anybody recall or have any at the moment? If not, we can definitely look back and talk about it and report back.
I remember the conversation, and I thought that we were talking about the entire sentence duration, whether it was, 2/3 in incarceration, 1/3 on supervised release, or if that supervised release had actually been reduced because of either a violation or some behavioral infraction during incarceration. But, I just remember talking about it, and unlike folks where there wasn't any incarceration, and I think we had an overall, well, I know my position was date of offense because COVID had stopped. I'm still trying cases that are 3 years old, for instance, and you've eaten up 3 years of that time. But certainly somebody who had been incarcerated, it seemed like that was the end of the entire sentence, no matter how much of it was in or out. I think is what we're talking about.
And I put a note just to double check that one. I think we could go back and look at meeting notes and sort of go back and double check that and make sure that that's clear. Mr. Esme?
Yeah, to that point, the next sentence after that, point 2, so it explains the suggestion is based on the idea that the time a person is crime free while on court supervision is less meaningful than when not supervised. To me, that's a hint that the subcommittee was thinking it would be the entirety of the DOC sentence, including the supervised release period. If it is not that, then I think that sentence doesn't make sense there. Right, because it's seeming to say that while you're on supervised release, we're not as convinced that the crime free period is as predictive as it would be if it was a crime free period when you were not under court supervision. Does that make sense?
That does make sense. And I think that's a good comment and definitely a good thing to clear up. And because, I think if you read them all together, that's what makes sense. But we'll just make sure, we'll double check and make sure that's clear. All right, unless there's anything else on the length, I'm going to move on to, or the date, excuse me, sorry. I'm going to move on to permanency. Hearing nothing. All right, permanency. And again, if any comments, suggestions, concerns, Ms. Kaser.
This is just a minor thing, but instead of calling it permanency, could we use permanent disqualification? Or permanency in my world just means something very different. And so that strikes me, just to clarify that. So
We're not talking about permanency and child protection.
right.
All right. And I think other than that, I mean, the permanent disqualification section is shorter. There's not much here. So unless anybody has anything, I'm going to move on to preponderance of the evidence. Not hearing anything. All right, moving on to preponderance of the evidence. Yes, Ms. Baum.
Good morning, everyone. I just wanted to clarify that I am here on behalf of Kalani Moti, who has had to run to another meeting. But we just wanted to clarify one piece around family assessments in our current practice. Right now, family assessments do not equate to maltreatment determinations for the purposes of determining disqualifications based on a serious or recurring maltreatment. However, we did want to say there are rare instances in which a family assessment is referenced in a police report, but in those cases, the police report and the investigation and observations by law enforcement contained in the report are considered evidence or facts in determining whether a POE for disqualification exists. So we are supportive of the recommendation in the task force because it aligns with our current practice and policy, and we just wanted the report to clarify that piece or to share that we do already exclude family assessment from the disqualification process.
Yes, thank you. And Ms. Williamson, I'll get to you in just one moment, as I think I understand, I probably know where you're going. No, I think that is helpful, and I definitely appreciate, while DHS may not itself specifically use it as we talk about, these statutes apply to other agencies and other entities. It's not just DHS. And so I'm happy to hear, and I'm happy for the support to actually codify specifically that family assessments will not be used, as I think that's very important, especially as we've highlighted, they are not appealable, but may be referenced in other places. And so I'm very happy for the support of that recommendation. Ms. Williamson.
Thank you, Chair Dawson. Want it to be noted here that, again, DHS is making a factual statement, which in my lived experience is not the case. I've already, shared my story somewhat, and the family assessment was not only referenced, but that's what was used as reoccurring, and there were no police reports that were attached to my case. So that is not a true statement that DHS is making. And it's been over a month and they haven't reached out to finalize and get the facts of my case.
I understand, and thank you. And obviously, as Inspector Moti noted, they should be reaching out to you, and I'm hopeful that will occur soon. Okay, so as far as the preponderance of the evidence, we've got the preponderance of the evidence would not be used. And then moving on, within the preponderance of the evidence, we have not just the preponderance of the evidence standard, but also the maltreatment. So I want to make sure before I move on to process that we've covered any comments or concerns or edits to either one of these recommendations. Ms. Kaser.
Hi, yes, I know I brought this up before, and maybe it's just maybe it's a wording thing that we need to clarify, because you're kind of making, it seems like there's two recommendations in one in this. And I feel like those need to be teased out a little bit more. So it seems like you're making a recommendation that maltreatment determinations be made at a clear and convincing standard, and that serious and recurring maltreatment, which is the only thing that is a disqualification, that process when the DHS is determining that family assessments are not part of that determination. Am I misunderstanding that, or?
So I think I want to be clear. So we're saying that the statute will simply be codified to say that, because right now under this, if you want to look at it, whether it's the definition section or maltreatments are actually covered under, there's a separate statute under 245C, and I apologize, I just don't have it handy. But essentially the statute will just be codified that when considering whether it is serious or reoccurring, family assessments will not be used in determining whether it is serious or reoccurring, that we will only look at formal maltreatment determinations. So the people actually get that letter that says that an investigation has been done pursuant to 260E, and based on a preponderance of the evidence, they're making that determination. So we're, and I realize I'm talking fast and you understand the language. So if somebody else does not, please speak up. But so we would simply be codifying to say that then when DHS is now looking, they're only using where there's been that formal determination, which I think is squarely within the power that that's within that 245C. We're not touching, family assessments have their use and have their reasons under 260E. So we're not touching that. And then what we're saying, and I think the logic was that maltreatments under 260, when we look at all of the offenses that are, or all of the violations under 245C.15, the majority are criminal, where those are the standard is proof beyond a reasonable doubt. The only, I think, other one, at least that comes to my mind off the top of my head, is an involuntary termination of parental rights. That has to be done by clear and convincing evidence. So maltreatments are really the only one that then are done by a preponderance of the evidence. So they're the only ones that are that lower standard. And I can at least say from the remedies subcommittee, we just wanted to make sure when we're talking about somebody's livelihood and their ability to work while balancing any sort of a safety concern, that we're affording sort of some extra protections. We're sort of raising this, again, only into the disqualification statutes. We're not in any way trying to invade 260E. 260E has its use, it has its purpose. But just that we're making sure that there is that additional process or a protected process, and people have the ability to protect their livelihood while balancing the safety of others. I think I see Mr. Esme, he's at the top of my screen. So if he has any additional comments or support for that.
That was a good summary. Nothing to add.
All right.
Sorry, I have a little friend here today because we have no school.
No, that's okay.
And I completely understand that, and I agree with codifying. So I just think the language gets confusing when we say it needs to be clear and convincing, because there's already that statutes that maltreatment determinations are of a preponderance of evidence. And so I worry if we put that language that we're recommending that be clear and convincing, we're going to run into just confusion and like I've talked before, unintended consequences of how does that impact other statutes. So I just wonder if there's a wording that we want to make clear around that. But I agree with the idea that is being proposed of that family assessment should not be part of that determination of serious and recurring, if that makes sense.
Yes, that does. Thank you. And I know in one of the things that we had talked about in the remedies subcommittee, it's not necessarily there. I guess it could be there for serious, but you know, an individual may get a maltreatment letter and it may not matter at that point in time as to whether the individual, and I guess I've had a number before where it's a minor who gets the maltreatment letter and, you know, the parents say, we're not going to do anything about this. Well, then the individual wants to go start working and maybe it's an allegation of sex abuse that was never appealed. Well, all of a sudden that creates barriers. So to me, I think we really wanted to focus on ensuring that individuals have the ability to work, they have process, and especially when we're looking at a maltreatment that is something that it's a letter that comes in the mail, and to an individual, they may not fully appreciate the other ramifications of it, but realizing they have their purpose and they are codified under 260E. We're just trying to make sure that 245C, I think, meets the workforce demands, obviously keeps in mind safety, but also protecting an individual's ability to work. All right. Okay, so unless there's anything specifically with that, I will move on to process. And I know here we have quite a few recommendations, and I want to be very clear that I think the remedies subcommittee fully appreciates, and I wanted to give a lot of support to, I think, the work that DHS is trying to do, and perhaps understand that DHS is working with what they have available and wanted to make recommendations to perhaps make this not only easier for applicants, but also DHS. Ms. Mattson.
Hi, not sure if we need to add more specificity here. I did kind of rework the paragraph to just be more specific about what we want to see, providing regular reports regarding the background study that includes statistics with the number of applicants by program, and then disaggregated data that includes outcomes by race, rather than saying racial disparities, because I just think we should be specific about what we want. And the number of disqualifications and their time for determination, and the number of set-asides and their time for determination.
I think that would be great, and I'm sure Will would very much appreciate your edits to that paragraph. You're getting a big thumbs up.
Okay.
If you wouldn't mind emailing those specifically to him, that would be great. Okay, and I am going to, I do have to go run and let my dog in really quick. Mr. Esme, would you mind if there's any specific questions, since you worked very hard on these specific recommendations? I will be right back. So just in the next 20 seconds, if anybody has anything.
Hi, me again.
Go ahead.
Just if there could be something specific in here that DHS should share pertinent dates of notification and submission of reconsideration with the employer. Oftentimes the employer were the conduit to the study subject. I know you're going to be shocked, but people don't always read their emails or read letters, and I'm sure DHS knows that all too well, but we would like to be notified so that we can assist and help monitor the process. You don't have to disclose information to us, but at least knowing the date would be helpful.
That makes a lot of sense to me. I wonder, it is a little bit of a like substantive addition that is beyond the recommendations that we voted on, but I also don't think that it would be very controversial. Will, do you have a sense of whether can we add that and then consider it adopted when we vote on the final version of the report?
Mr. Esme, yeah, if Chair Dawson directs me to do so, I think I'm on good grounds to interpret that as the will of the group.
Yes. Yeah. And Ms. Mattson, I see your hand is still up. Were there more specifics?
No, not for the next, I think one. Thank you.
Okay. And I guess I do want to be, since I do know that we did lose Inspector Moti, DHS had given us, I think, some specific comments and thoughts about some of these. And so we'll, again, sort of similar to what I said at the beginning, we'll make sure we're going to try to incorporate them. They're more just practical and wording, kind of how to make it all work type thought process. So I just want to be, if people, or when people get the updated version after today's meeting, there could be some pieces that were more suggestions and recommendations from DHS. But I think overall, as part of this process, DHS, my interpretation was very supportive of wanting to also modernize the process so that we're not just looking at a mail and type process. And if I remember correctly, I think also they were very open to and looking at some sort of even an online portal and trying to make sure that this is accessible to individuals. So I do definitely want to point that out. And I think I was scrolling, so I hope if there's something specific, just because this one has a number of different paragraphs and recommendations, that if there's something specific. Ms. Baum.
Hello, yeah, we would just like to make a comment about the provision related to police reports. Just to clarify a misconception, which is that DHS currently does not obtain police reports for all disqualifications. We only have police reports for preponderance of evidence reviews, and in very limited circumstances, we may have complaints or police reports to help assess an interim risk of harm, or what we call rat back information related to new criminal cases. Requiring us, as this recommendation indicates, DHS to obtain police reports for all background studies could have a significant cost and create additional delays in completing the background studies as we wait for responses from police departments, which have no statutory obligation to prioritize us or our background studies. So we would actually require additional funding and full-time staff to implement this recommendation, which is why we are concerned.
Ms. Baum, can I ask a clarifying question?
You may.
It is sort of currently the case, though, am I right, that DHS wants police reports in connection with basically every set-aside request? Is that right? Or are police reports not really considered in some subset of set-aside requests?
Hold tight for that response, because I'm messaging my team. I will see if they can help me out here. Maybe could you repeat the question, Mr. Esme, just so that.
Yeah. Because you mentioned that DHS gets the police reports themselves for preponderance of the evidence reviews and for some risk of harm analysis. So what I'm wondering is, looking at sort of the broad set of everybody who may be asking for a set aside, do we need police reports for all of those or not?
It's a great question, Josh.
Yeah, I am hearing from them, from my team, that police reports are always considered when they are received in a reconsideration.
Right. And then for a lot of them, the department is getting them through the applicant, who gets them as a part of the set aside process themselves, right?
That's my understanding. And my team can correct me if they hear me, and if I'm incorrect there.
So I guess I would just, from my point of view, that is all an entirely legitimate concern and maybe a reason that the legislature doesn't adopt this suggestion. But I think that the suggestion still makes sense from the perspective of making this process accessible to the people who need to access it. And, you know, if that would also require, you know, creating some language that has police departments prioritize department requests for records, I'd be all on board with adding that to our recommendation. But yeah, that's sort of how I see it. Like, I totally understand that there's a tension here between, you know, which party is responsible for the burden of this task. But I think that's sort of what our subcommittee was thinking through when we ultimately decided to adopt this recommendation in the first place.
Yeah, and I think, and Ms. Williamson, I'll definitely get to you here in just a moment. I think another point is, you know, if an individual only has so long to respond, but they're required to respond with a police report, I've had it before where perhaps a client is not able to even get a police report, and somehow I have to get either a court order or go some other route to try to get police reports. They're not always accessible. And we sometimes get pushback from certain police departments. It seems some are more willing to release records than others. Some require you to drive there. That something, because I can appreciate that DHS would like them and that they may be required, but there's only so much time. Ms. Williamson.
Thank you, Chair. I just want to briefly add that in my example, or in what I experienced, there again was no convictions. There was no, you know, the police report was just in regards to the visit for the assessment. No convictions, nothing of that nature. However, it was still considered enough to list reoccurring. So again, I welcome being able to go over the facts of the matter. It just hasn't happened as of yet. But this was false that was made.
Thank you very much. And Ms. Evans?
Yep. And I just would like lived experience, and I haven't spent a ton of time talking about that during this time, but like hearing Ms. Baum talk about requiring them to obtain police reports and that they don't get you know, any special dispensation from law enforcement, and the amount of time that takes. And like, I feel that in my soul, the amount of work that was, having to go get police reports from all of the counties that I had been involved with and some of them were like, we don't have that anymore, right? It's been 13 years, we don't have those files anymore. And having to communicate with like no one through, you know, lucky for me, Teen Challenge had a person that we worked with that I could like get an email to and be like, what do you want me to do? Like, they don't have this. They don't have this document. And the person told me to send a copy of the email that said that they no longer have a copy of the report or whatever. And so, but that's my privilege, right? Not everybody has somebody that can get in touch with DHS. And so like I understand that, but that you guys don't have the like resources to be able to deal with law enforcement in 30 days, right? Or 15 days, like either do we. And so how, like, what is the compromise? What is the alternative? What is the, like, what is the different thing for folks?
Mr. Esme.
Thank you, Chair Dawson. I wonder, Will, if you wouldn't mind taking a stab at adding a couple sentences to this one that acknowledges the administrative burden that it will create from DHS, and then adds to the recommendation that the legislature adopt other changes necessary to accommodate the additional administrative burden, including funding provisions and access to police department records for DHS.
I
I'm
think
definitely
that,
I'm sorry.
no, I was gonna say, I think that makes sense.
Okay.
And perhaps even sort of in the alternative, then something else to allow an individual to appeal, just something to allow the process to still happen, whether an individual can provide the reports at a later time, but something so that an individual does not miss their reconsideration window. You know, essentially something needs to be done to fix that, I think, is probably the answer to all of this. Ms. Evans, is your hand still raised?
No, ma'am.
Okay. All right. And it's 11:46, everybody. The goal was to go until noon. So if we don't get all the way through this, please, please, please email any comments or concerns or edits to Will. I'm going to do a hard stop at noon. This has been a long but very productive meeting, but I'm not going to ask anyone to go past noon. So moving on to the waiver of, and I'm gonna sort of go through these, I guess, just a tiny bit faster. So if there's something specific, please speak up. I'm not trying to approve this just by scrolling past it. And again, I know that DHS had some specific comments, so we will definitely be incorporating those and working those in. Ms. Mattson.
Yeah, I'm on the next one, DHS response time.
Yes.
Okay. If we could add in, shall notify the applicant and the employer. And then just to note that we think 6 months is a little excessive for a final decision, but understand that it's been voted on, so.
And I think, Ms. Mattson, if memory serves me correct, that 6 months had been just because sometimes we're seeing even longer than that. And so, and Mr. Esme, correct me if I'm wrong, but we've seen even longer than that. And so 6 months sort of felt like we had to put a cap somewhere.
Yeah, no, we definitely are aware and, you know, appreciate the work here, so.
Yeah. Oh, sorry, go ahead, Mr. Esme.
I was just going to say, and that's also why the other part of it is that DHS do everything they can to allow the person to work while awaiting that final decision. Recognizing that 6 months is really long.
Ms. Sherlock.
Thank you. I want to echo the 6 months. I have a concern with that length of time as well. I understand that there may be barriers right now to getting things done faster, but perhaps that means that the process needs to be simplified or they need more staff at DHS. 6 months is a very long time to be waiting on employment, but it's also a very long time for counties to be paying county dollars for placements because we cannot license foster parents. while we're waiting for this process to complete. So there's also financial stakes for all of the counties of Minnesota about this.
And Will, I would definitely approve you to make sure you add and highlight these concerns and the additional funding that's required. And that while, 6 months, yes, is there are definitely voices and concerns that even that is too long.
Thank you.
Yes. Thank you. Ms. Mattson. Oh, nope. Okay. All right. So I'm scrolling through the difficulty with traveling set-asides. And again, this one here, I know, just to highlight, there had been some concern as to how this all worked within the statutes. And so I think DHS was also in support of this, I think, if I remember correctly, trying to figure out how to actually make these work. So I am scrolling again. Ms. Mattson.
Yeah, and same thing. This is kind of a broken record, I guess, here, but again, if DHS could share applicable dates and types of correspondence with the employer who submitted the study on behalf of the study subject, just so that there's, it references here.
Which one are you looking at?
Issues with accessibility, ESL, communicating and writing.
Okay.
Just to not lose sight of the fact that the employer is the conduit to the study subject.
And often an ally.
Yes. Well, yeah, we have a vested interest.
All right.
Me again.
Yes, please speak up.
On the community resources, in reading this, it could be just a list of community resources that's always posted. But if it is directed specific to the disqualified individual, we as the employer would also like to receive the information so that we can see, again, that reference, they ask us questions.
Thank you. Ms. Robertus.
I can't remember where it is on page 19, but we talk about recouping attorney fees and things like that. I can't help but feel for DHS a little bit as we go through this, right? They're the state agency that has sort of been tasked with this responsibility. And so I'd just like to echo that some of our asks are going to be quite demanding. Hopefully with some of the recommendations, it does equate to reduced workload as well. But I think stressing in this somewhere that we recognize fully that DHS can't just take these recommendations at the current state they're at. And for state agencies to get additional resources, it's a very rigorous process and sometimes often very difficult. And so I just want to stress that this can't be successful without adequate resources. And then when it talks about like recouping, it doesn't really say who should be responsible, but just because DHS is asked to do the work to check, do the background studies, does that mean that they're then responsible for recouping these fees? I'm not sure that translates for me, but those are just my couple of thoughts. And then I think that's all the notes I have.
And I think the accountability was here. It's definitely important. And I think obviously keeping in mind that an incorrect decision, of course, keeps someone out of work and wanting to make sure, but I can definitely appreciate what you're saying and that it's very clear changes do have to happen and things of that nature. So thank you very much. Mr. Esme.
Yeah, about a small little one on the expungement paragraph there at the bottom of this page, which is a little embarrassing because I think I drafted this language originally. But third line, where it says the individual speaking the expungement to undergo the full expungement petition process. So they don't need to undergo the full petition process if, and I think after that, if there, we need to add, they meet the statutory requirements for expungement, comma, and the prosecutor agrees.
Okay. I am still scrolling. So then we're getting into the appendix. I got appendix A. I guess unless we're at 11:55, since these are, I guess my thought would be sort of the last 5 minutes for any final kind of remaining comments. And I guess if somebody has a specific issue with any of the remaining pages, maybe just email that to Will. But last sort of 5 minutes, because Will, after this meeting, will, Mr. Vogel will, there we go. Of course, be updating this document and emailing it out. And I want to be very clear for everybody as you're looking at your calendars. The plan is to vote on the final report at the next meeting, December 16th at 10 a.m. So please, 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 all of us have put in countless hours to do this work, and it is important that that we're here to cast that vote and to really, you know, we've done the work. We should be here to have that final say. So if everybody could please make sure they have that on their calendar. If for some reason you don't, please email Mr. Vogel, Chair Geffen, any of us. We'll make sure that you have that. I know, just make sure. And obviously, Mr. Vogel will get that sort of final draft out, obviously, as soon as he possibly can, so that everyone has time to address that and to review it. And I think come prepared on the 16th. You know, I'm sure there will be some discussion as we're looking at this, but please come prepared, as that is, that's our last chance. Any questions? All right, well, if there's nothing else, we can adjourn a few minutes early. And everybody enjoy your weekend. Enjoy the craziness that is this time of year. And we'll see everybody next Friday.
Thanks, everyone. Appreciate you all.
Thank you, everybody.
Thank you
Thanks
all.
for leading us today.
Thank you. All right, bye.
Thanks, everybody.
Great job, Will.